All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta-Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for children's rights, transitions, money, normalcy, siblings, and relatives. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you register, you're going to receive a copy of the recording, you're going to receive the CLE code, and a link to the materials as well. We will be posting it on YouTube, so if for whatever reason you missed out on registering, you're going to be able to find it on YouTube within 24 hours or so. The training was approved by the Florida Bar for 1.5 General CLE credits and 1.5 Juvenile Law Certification Credits. So I will announce the CLE code towards the end. I will drop it into the chat. I will also include it in the email that goes out from Zoom, and I will also include it in the YouTube description. If you need a certificate of attendance, make sure to email me after the webinar is done. I will make sure to get all those done at the same time as the emails come in. So closed captions are enabled for anybody who needs them. Sorry about barking. For anybody who needs them. So if you're having any issues with accessibility, let me know and I will make sure that they are working. So if you have any questions, you can use the chat or you can use the Q&A feature. We'll do our best to answer questions if we can as the presentation goes along. If not, we will try to address as many questions as we can towards the end. So with all of that said, I'm going to pass it on to Robin first. First to Robin.Rosenberg with Florida Children's First, so we can get it started. So Robin, the floor is yours.
Thank you, Jorge. Good afternoon, everyone. It's great to see your names, at least online. So I am very excited to kick off our webinar series on training series for Florida's Children First. Those of you who have known us for a long time know us as an advocacy organization that promotes the rights of children that are served by the state, primarily foster care, and we work on, we have always worked on systemic reform, improvements to the law, supporting attorneys and guardians ad litem and judges who are working in the child welfare arena. In the past couple of years, we've had the opportunity to expand what we do by adding 3 attorneys to our staff. And they are, along with me, will be doing all the trainings in this training series. And not only are they awesome attorneys and advocates for kids and knowledgeable about lots of areas of the law, they are available to take cases. So we are able to represent children and teens in foster care, as well as young adults who were formerly in care or who are homeless on a whole variety of matters, directly in dependency, but civil matters as well. And so please reach out to Florida's Children First or me personally if you know a child that you think needs legal representation. Christine, can you flip to the next slide, please? And as I said before, one of the things that we've always done is support attorneys and judges who are working in this arena. And I want to make sure that if you are a lawyer or judge, and you're not already a registered user of the Florida Dependency Law Center, please take a minute to go online. You'll see the link at the bottom there, floridadependencylaw.org. It is a free website, but it is only open to attorneys and judges that are in good standing with the Florida Bar. Register, and that's one way that we can stay in touch and provide resources to help support you in your practice. So that's the pitch that I wanted to make, and I'm going to turn it over to our executive director, flashback, Geori Seldine, who's going to take up the next part of this. Geori.
Thank you, Robin. Hello, everyone. Good afternoon. Thank you so much for coming to our training. We really appreciate you attending today. As Robin mentioned, my name is Geori.Berman Seldine, and I am the Executive Director of Florida's Children First. In Florida's Children First, we do a lot of really great work. One of our main programs that we have is Florida Youth Shine, and that's a youth advocacy organization of current and former youth from the foster care system or those that experience homelessness ages 13 to 26. And we have 14 chapters around the state, and we empower them to be advocates in their community and around the state. And we do community education and training, legislative change, executive branch work, all different types of advocacy with our young people. Not only does Florida's Children First support them, but Florida Youth Shine supports us by informing us on our work every single day. Now, back in 2018, or even a few years before that, they identified the issue of not knowing their rights and the laws and resources available to them in the system as one of the main problems that they're experiencing in the system. So in 2018, we set out to work with the legislature to ensure that young people are educated about the laws and rights. And I am so excited to share that in 2023, if you haven't heard, that bill passed and became law, that young people are educated about the rights, resources, and laws available to them in care, because we know the system is complex. So, the Florida legislature has really a lot of provisions that are in place to benefit and protect children. However, we've passed all these really great laws. There's things like normalcy and driver's licenses and sibling separation and a lot more, but they're complex. And we realize that our young people were saying, well, we don't know that we can get our driver's license. We don't know about these things. And they're all throughout the statute. We also found that, while some families and youth provide positive reports about their interaction with the system, more typically they felt overwhelmed, confused, voiceless, judged, ashamed, and angry and sad, or they were feeling powerless, like they did not have a say in their own lives. They didn't know where to turn if there was a decision, and they really had difficulty envisioning their future, which was one of the things we were hearing most from our young people. How do we know we can go to college if we don't know there's a tuition exemption available to us? So why is it important for young people to be educated about our rights? So we've really set out to do that. Obviously, it's in the law now, but Florida's Children First, it's one of our main priorities to make sure that our young people not only know the laws, but that they understand the law, and in turn that their foster parents and case managers and other folks in the system and attorneys and GALs are all working together to make sure that our young people are educated about those laws. So we believe that youth should be educated in a developmentally appropriate way about those laws, intending to benefit and protect them, and also have somewhere to turn to navigate those laws. And we say an age appropriate way, developmentally appropriate way. Really, a young person can understand that with a cartoon or a picture, or if they're a teenager, that they're educated with a conversation in those developmentally appropriate resources. Also, because knowledge is power, as I said, youth don't know about those existing protections, and then they have difficulty envisioning their future. For example, a child may think that they can't even try out for, the football team or go to college or have a job just because they were in foster care. So this knowledge can really ensure that children have the skills they need to achieve financial stability and independence. Listening to youth and acting on the information that they provide that would be most helpful for them can really lead to those improvements in the system of care and increase positive outcomes. And we believe that children who are empowered to speak up about their needs can reduce costly long-term societal problems such as criminal system involvement, imprisonment, unemployment, homelessness, and the list goes on and on. Also, we know the child welfare system is complex and can be scary, especially to children. It was really sad that we heard for many years, I didn't realize that I was supposed to be kept safe when I came into foster care. Young people just had this stigma of what foster care was, and they didn't know there were laws in place to protect them. Also, caregivers and individuals working with youth often don't know about the existing laws or how to educate young people in a developmentally appropriate and consistent way. So we know that educating youth really helps you also build relationships. If you sit down and say, oh, you can go to court, let me help you go to court. Well, let's figure out transportation. They start to build that relationship with those people that are empowering them and educating them. So that's why we think it's important for young people to be educated about their rights, just some of the main things. And there's a lot of topics. And if you have young people that you're interested in joining Youth Shine, please reach out to us as well. I'll turn it to Christine now. You're on mute, Christine.
Thanks so much, everybody, for joining in. I am Christine.Smith, and I was one of the first attorneys that joined Florida Children's First as a direct advocate for children. I've been doing this work since 2007, and I recently became board certified in dependency. So with that, let's get started. I've entitled this as Basic Rights, and every single one of these slides, when you get them, is linked to the statute so that you can, when you're advocating and using these slides, hopefully later on, you'll have the slides and the link. You can click the link here or on the actual underlying statute, and you can have that. These in the statute are listed as goals, but the rights stem from other rights in other parts. For example, the right to privacy and the right to uncensored communication. And those are all civil legal rights that belong to foster children. And those civil rights are not given up just because they are put into foster care with something that they had nothing to do with. They're in foster care, they're in the child welfare system, not for anything that they did bad. And so they shouldn't have to give up the right to privacy, the right to have their belongings, the right to uncensored communication, and the right to access, those communication tools just because they're in foster care. So although the statute reads that these are goals, the rights are basic rights that either come from constitutional rights or they come from other statutory references, and you'll see those statutory references as we move along. Number one, they have a right to be in an environment that's abuse, abandonment, or neglect free. If we take children away from their parents, we have to do better than the environment that they were removed from. So with that, we're going to go through each one, kind of parcel it out. And if you have any questions, Jorge and Robin will be moderating and we can jump in. We have a lot of ground to cover. So with that, we'll head right into transitions. Now, transitions, when we talk about transitions, we're talking about when kids come into care, when it's initiated by the department. And then once they're in care, if there is a need for disruption and they have to change placements, or if they are going to go home, we want that reunification to have a transition so that it can be as successful as it can be. And then we have transitions initiated by others. For example, if we are going to move children to be with relatives from foster care, or to be from a single placement into a sibling group placement. Those are the types of transitions that we're talking about. And in here, the legislature has put into play Florida Statute 409-1415. And this really gives oomph to the idea that foster parents and birth parents are supposed to be developing a supporting relationship with caregivers. We have kids coming into care quickly. The handoff between what the parents know about, say, a medical history or what they need. If we pit foster parents and biological parents against one another, that flow of communication is hampered because everybody feels badly about one another. So the legislature requires DCF and the CBCs, the community-based care centers, to develop supportive relationships between those caregivers and birth parents, because it ultimately helps children. Just like in divorcing families, you don't have to like each other or love each other to support children. I've done divorce law and family law in addition to dependency for a number of years, and co-parents don't always like each other, but that's okay as long as they're civil and respectful and can keep the eye on the prize and keep your eye on the ball of supporting children. That's what we expect. So they should be collaborating to give children the best, and that's what what the legislature designed, and that's what we expect for kids. And we also give the child the appropriate, if they're age appropriate or developmentally appropriate, the right to participate in case planning. I don't often see that in my cases. For case planning purposes, Attorneys ad litem typically will go for the child, but I always extend the invitation to the child to make sure that they feel like everybody in the room is talking about them and their family, and if they want to, they can come. So when we're talking about transitions, if a child has to be moved for those reasons that we had in the previous slide, who gets notice? The department must give 14 days notice before a move, and that move intention should be filed with the court. And there's your statutory reference, unless, of course, it's an emergency and those things happen. Why would that happen? For safety reasons. Sometimes a child has to be moved. The legislative findings that are overarching on transitions is that it's recognized by the legislature that multiple placements cause trauma. We have some kids, unfortunately, mostly teens, who are multiple placements by the time they get to be teenagers. And poorly planned transitions can cause harm, right? Because they don't get the continuity of services, they don't get the continuity of education. And so we should be prioritizing minimizing placements. We shouldn't have those kids in care who have 50 placements. And happily, I just finalized an adoption, I want to say a month or so ago, for a 16-year-old who had over 50 placements. That's not what we want. We don't want to have a kid who has had that many placements. I will say that I jumped on the case late in the game, post TPR, after this kid had so many placements, and during my tenure as his attorney, he did only have just the one placement that was his adoptive placement. So stability is key for kids. And each child's transition is not cookie cutter. It should be unique for each child. And as part of that legislative scheme, we need to be doing transition planning. It's mandatory. There's our statutory reference 39402. It's a place where all people that are important to the child are gathered on the table so that we can best determine how a move should happen. The multidisciplinary team, which is abbreviated, oftentimes you'll see it. We love acronyms in dependency, so you'll see it as MDT staffings, and they must be held before moving the child, or 72 hours after if there was an emergency. And the child should only be moved for the reasons set forth in the statute 409-1415 to B7. And those expounding on the MDT staffings, they're required for emergency placements and planned changes. So we should be doing them when there's an emergency. It's done after the fact. So I had a kid who disrupted because he had a higher level of need. He was in a group home, and it was an emergency. However, we gathered around the table after the physical move to do the educational transition. So he stayed in his original placement with his education and his original school until we could get that transition plan in place. So sometimes we have emergencies, but even with the emergencies, we still should be doing MDT staffings and getting together a logical and thought out transition plan. These are the reasons why we have the staffings for locating missing children, for human trafficking placements, because those kids will likely have special needs that are different from other kids. When we have reunifications, when we have sibling separations, or even when we have moves to reunify siblings, placement transitions for in and out of foster care, and for children in placements for 9 months or more. We'll have more on that slide because I know there's a lot more to just the 9 months. And for education and early childhood changes and reinstatement of parental rights, which it doesn't come around too often, but it is a reason to have an MDT staffing. And who must be invited to the staffing? Sometimes when I'm in a case, if I'm not always appointed at the very get-go, and the MDT staffings are kind of humming along, and everybody that is known to the case is part of the staffing team. And then maybe you have a Johnny-come-lately attorney added to the case like myself. Maybe when it gets to be around TPR time to weigh in on sibling separation, to represent the kid when there's permanency decisions being made. And so sometimes I don't always get invited. And I have to remind folks that I should be invited because the child and the child's representative should be invited. So sub A says to child, unless he or she is not in age of capacity to participate. And sometimes maybe they don't participate in the entire staffing, but I had a kiddo who recently just popped into the staffing to say what he wanted as far as, do you want to go to a different school or do you want to go to the same school? And he popped in just for that limited question to answer that, and then he kind of lost interest and didn't want to be part of the rest of the staffing. But I think it's really important for kids to have a vehicle for their voice to be heard. So this is I like to say this is kind of the behind the scenes work that happens before we have a court hearing, where everybody comes to the table, everybody that's on the child's team, and we flesh out all the details so that we can kind of have a cohesive plan when we get to court. The child's family members and other individuals identified the family as being important to the child. As a child advocate, I'm biased and I admit it, but that's okay. I think we should be viewing it from the child's point of view, because that's what I do every day. So again, no shame in my bias, that people that are important to the child should be invited to the staffing. And provided that a parent who has no contact order and injunction, of course, we have to be sensitive to injunction cases, or is not subject to a termination of parental rights, may participate. The current caregiver and a representative from the Department of Children and Family, the CLS attorney, and the representative from the community-based care, the CBC. And oftentimes there's multiple people from the CBC. Sometimes they have people that are scribing and supervisors, and just a myriad of other people. And so these are the must attends, or who must be invited. And then the next slide is who may be invited. A representative from Children's Medical Services. So if the child has special medical needs, of course, we want to hear about that. We want to hear about the provision of services and how that is going for the child. A guardian ad litem, if one is appointed, and typically we see the CAMs and we see the guardian ad litem attorneys. School personnel, I think depending on the student, and particularly when we're working on transitions related to school, I think it's really a great idea for school personnel, and not just the representative from the school. Like and one in the recent past, I had a kid who was being a little bit disruptive. And so not only was the principal on the staffing, but the teachers who had direct contact with the child, and they had him on a behavior contract, so that we could hear firsthand from the teachers what was going on, how he was doing, and keep the progress reports flowing. It was a way for everybody to come around the table and kind of manage behaviors, set expectations, and the like. A therapist or other behavioral health care professionals, I think that's really key. I think it's great to know how often a kid is going to therapy, how it's going. We don't really need to talk about the actual guts of what goes on in therapy, but if a therapist does have a recommendation, we're all ears. And we want to hear from those professionals. A mental health professional whose expertise is in sibling bonding, particularly if it's a sibling separation staffing or sibling reunification staffing. We want to know about those sibling bonds. And then here's our catch-all: other community providers. or stakeholders, anyone who is important to the child's child welfare case, we want to hear from them. And we have what must the MDT team consider? This is from 3901375. These are some statutory guidelines and some statutory frameworks so that the MDT team has an objective measure of what should be happening in those staffings. So what are we considering when we're in those staffings? We're looking at the child's age. So in my case, as an attorney for a child, if my child asserts a position, of course their age is going to be considered. If I represent an 8-year-old versus if I represent a 17-year-old, we're going to be looking at their capacity to understand what's going on and give that the proper weight. The physical, mental, and emotional and health benefits of remaining in a placement versus moving for that placement. Like, what is the cost versus the benefit of remaining in the placement versus moving? How long has the child been in the current placement? What bonds are there between the child and the current or proposed caregiver? The preference of the child considering their age and capacity. So not all children are created equally. One 15-year-old might be 15 going on 30, whereas I might have the opposite and have a 15-year-old that has maybe a slight lesser capacity that might be more along the lines of a 12 or 13-year-old in emotion and cognitive abilities. The recommendation of the child's current caregiver, the recommendation of the child's guardian ad litem, what is going on with the sibling bonds, and what will happen if we separate versus if we reunite. So we're looking at the move in terms of what is to be gained versus what is to be lost. On the sibling bonds and the likelihood that the child will attain permanency in the current or proposed placement. So we're looking at if we make a move, is the timing right? Does it make sense to move a child if they're a month away from reunification? Because that might result in a move. So maybe we don't want to do that. Is a change in school required? And if so, we need to put an education plan in place and look at the what's required for that. We also want to be looking at what services the child is getting, and will they lose those services? Will those services be available in the new placement, and or will they have to change? For example, are they going to have to change therapists? And therapists for kids change a lot. Unfortunately, most of the kids are on Medicaid, and those therapists sometimes are not always the therapist for the child, which is a bummer, because once the child kind of opens up, gets a rapport with that therapist, it's always good to have that continuity. And so what are the services going to look like for the current placement versus the new placement? And then we always want to look at the child's history of abuse, abandonment, or neglect. And so, for example, if the child's proposed placement has ties to the abuser, maybe it's the abuser's family, and they have minimized the abandonment, abuse, or neglect that the child suffered, we want to look at that. And also, again, looking child-centric here. How will the activities that are important to the child be impacted in the current placement versus the new placement? I'm thinking of, all kids are important, but as teens, what activities that they participate in becomes a big part of their identity. And if they're a star soccer player and they want to stay on the same team, we'd be looking at that and how they maybe could have some continuity and plan that out, map that out. How is their access to education, Medicaid, and independent living benefits going to be impacted? And really, again, we have kind of a catch-all hook, anything else that might be popping up in the kid's life. So just to reiterate, when we move a kid, when they're transitioning, we're breaking apart the idea of the physical placement and the education planning. They're two separate but related things. A kid can move placements without moving schools, or they can move schools without moving placements. Sometimes when they're maybe they'd be considering a choice school, or maybe they want to attend a vocational training school. So education planning is mandatory. It must be individual for the child, and we want every effort to be made to keep the child in their current school if we can. Moving around, making new friends, having new teachers, being exposed to a whole new environment at school. School is where they spend a good deal of their time, so continuity in their school is always favored if we can help it. Consideration of which school a child will attend if a change is necessary. So what's the target school if we do have to move them? And I have not been managing the chat, but we'll take a quick audience poll. Can the cost of transportation be a factor in our best interest determination? Because all of these factors and all of the things that are going on in the MDT, it really all distills down to the best interest of the child. We have some objective standards, but at the bottom line, they all should be rolling up into a best interest. So can the cost of transportation be a factor? No, it cannot. And I know transportation is costly for the department. I know I'm in the Hillsborough County area. We're a large geographic area, and transportation challenges are a thing, but the cost cannot be used as a best interest factor. So if you were in the chat and said no, you are correct. Okay, so there's a lot going on in this slide. I tried to distill it down, but as we went along, when I was preparing these slides, I wanted to make sure that I highlighted any new changes to the law. And Florida Statute 39522, we oftentimes call it the MOP statute, for the modification of placement, MOP. This was updated in 2024, and the department initiated moves should only be for safety, reunification, move to permanency, or removal if it's demonstratively in the best interest. So I think that adjective is important. A lot of the times we have competing good goals in child welfare. So for example, what are those competing good goals? Maybe we have a proposed move to a relative versus keeping the child in a relative placement. Maybe those are two competing good goals, and so if it's demonstratively in the child's best interest, then we should move. Otherwise, there was built into the statute a rebuttable presumption that at 9 months, that the rebuttable presumption for the child to stay put in where they have been kicks in, but only if all the conditions were met. Which this at the bottom we have a recent case that I was reviewing. I actually saw it a couple of times. I saw it when it first came out. I saw it again at the Dependency Summit, and then I really read it in preparation for these slides. And so it's not just the 9 months. The 9 months is kind of an easy way for you to think about it in your head, but you need to know that it is all 5 factors that have to be there before the presumption kicks in. So in order to get the rebuttable presumption, the child, and what is the rebuttable presumption? That is meaning that there's a presumption that the child stays put if they've been there for 9 months or more. That is not the end all be all. You've got to have the other factors in play. So we have to have reunification is not a permanency option. So we're not talking about, none of this applies to reunification. If the parents have finish their case plan and the child is going to be reunified, none of this applies. If a caregiver is a permanent option, and they're willing to be a permanency consideration, then yes, that's one of the factors. If the current caregiver is not requesting the change placement, so if we have somebody coming in at the tail end after the case has lived its cycle and the rights of the parents are being terminated, and now we're thinking about permanency and where the child is going to be either adopted or live in permanent guardianship land, those are the factors. And also that the proposed move is not to reunify the child with his or her parent, sibling, or from non-relative to relatives. So really this number 5 factor was what this case was about. So the case was involving foster parents and relatives both wanting to adopt. So here we have the two competing good goals. Good goal of having the child have continuity and staying put, and the good goal of being with relatives. So child was in the care of the foster parents for longer than 6 months. Caregivers were not entitled to the presumption, the 9-month rebuttable presumption that it was in the best interest for the kid to stay put, because the other alternative caregivers were relatives. So that would frustrate reunification with a sibling under the care of the maternal aunt. So really it was the hook was that we were in this particular case, KJ was the proposed placement was going to be with an aunt who had a sibling. So it failed. The foster parents were not entitled to the rebuttable presumption because of factor number 5. So that's a new statutory update from 2024. And this is just kind of laying out non-emergency versus emergency, the notices and the multidisciplinary staffing, MDTs, those are the timeframes. We're going to hold those 3 weeks in advance, 21 days before a move, unless of course it's an emergency. And if it's an emergency, then it just happens. And then upon the request, if there is a probable cause to shelter, here are all the things that happen in rapid fire ways. And if a child is not in licensed care, DCF moved to modify the placement within 1 business day. We have to have a hearing within 24 hours. The court receives evidence, and they have to hear that 24-hour, that evidence has to be heard within 24 hours unless the caregiver agrees to the placement change. Most of my in my experience, most of the emergency changes are coming from disruptions from when the level of services to the child are not adequate, and the caregiver is not necessarily fighting the transition because it's just, it is what it is. It's an emergency. And then transition planning is required within 72 hours. So if we have to move a kid, we still need to do that transition plan. And now we're switching gears, and we're going to talk about what every kid in care wants to talk about: money. How do I get it? What can I get? And who can blame them? That's we live in a capitalistic nation, and they want to know how they can get money and where does it come from. And this is that's again the child view, but for those of us who are in the child welfare system, it's important to know what sources of information and what sources of funding are for the kids. So are these direct dollars? We have our little graphic here with hundreds of dollars of bills just being doled out. Is that realistic? No, kids in care don't necessarily get dollars to their pocket unless it's through an allowance or flowing through eventually from a master trust, but we'll go through each one of these things. So when we have teens and older youth, we want to encourage employment. We want to educate ourselves as practitioners about supplemental Social Security income, and also SSA, which is the any veteran benefits, railroad benefits, death and retirement and disability, the allowances, which is cash dollars to a kid's pocket, and individual development accounts. This also fairly new in 2024, foster prosperity grants. This is a new program that creates grant funding for literacy, for financial literacy, LSAT, ACT, and CLT prep. And I think this one's great, trade, careers, and apprenticeship. Not everybody is college bound, and we've had PES around for a long time. And we have the extended foster care, which does cover training programs. But if kids kids in care, before they get to that aging out, if they can get into an apprenticeship or a trade, I think that's really a good change to our statutes. If they do reunify with a parent, they still remain eligible for the grant for 1 year post reunification. So I really like this new statute, and there's also changes to the Florida Administrative Code that are coming out as a result of this. So let's talk about employment for kids. Older youth in care should be able to work unless there's a good reason not to allow it. There's no 100% statute that says that. There's nothing in the statute that says kids have a right to work. However, it comes really from the idea that when a child turns 18, they really need to have those independent living skills already humming along and going. Otherwise, we're not doing the kids justice, because they won't be able to take care of themselves. And so the case plan tasks should be developed to develop relationships, coping skills, and emotional well-being. And I know from my own personal experience, a lot of my lifetime friends have come from where I've worked, and who I've met along the way. And I think anything that we can do as practitioners and working with kids that helps build their network of healthy relationships is going to ensure their success as adults in the future. And so in Florida Statute 409-1415 2B15, a caregiver must ensure that a child in his or her care who is between 13 and 17 years of age learns and masters independent living skills. So we have a whole independent living program for this age group, but it's also on the caregivers to support that. Well, how do they support independent living skills? Well, we would encourage them to help a kid get a job, take them back and forth to work, do everything that they can do that's in their power to do to equip a youth who is marching on towards adulthood to make sure that they can live independently, and employment is a huge one. So in that case plan development, the department shall prepare a draft and for each child receiving services. So I encourage those that are working with youth, put your, a lot of the times when we're talking about case plan development, we're very focused on reunification, and that's great. But we should also be thinking about if the kid, usually in my experience, it's about a year, if not more, that a child is in care, even if the eventuality is if they go home. And so we can't afford to be not making use of the time. And so in addition to case planning tasks for the parents, we need to be thinking about case plan tasks for what would help the child march towards independent living skills. So that case plan must be developed face-to-face in the conference with the parent of the child, the court-appointed guardian ad litem, and if appropriate, the child and their attorney, and the temp custodian of the child, so the caregiver. And I say practice tip here, and I did this series with the youth, mostly our Florida Youth Shine youth, and I encouraged them to think out of the box. Don't just, my encouragement to them was, don't just expect everybody to do everything for you. Leverage your networks, talk to people that are important in your life, talk to your teachers. If, like, let's say you work at or you're going to a school that has a Starbucks next door, maybe you can walk there and then all you have to do is get a ride home. So if the youth wants to work, and they all should want to work, get it in the case plan, and discuss it at your staffings so that everybody's on the same page, that we can get a consensus, and importantly, the support. These kids, they need, they haven't oftentimes been taught coping skills and life skills, and so we all need to come together to try and give them that support. I recognize transportation is always challenging. One of the staff on our FCF staff used to work as an independent living case manager, and she said that there was a kid in care who wanted to get a job, but there was only one transporter for the group home, and they had maybe half a dozen to 10 kids at any given time, and so everybody's going to load up in the van and take the one kid to go to school, or to work rather. It was a challenge, and I recognize that, but I say that if we get everybody at the staffing table, and there's all sorts of people in the community that we can help leverage, utilize mentors if possible. I know the Guardian Ad Litem program has really been launched, and one of their directives is to help get mentors involved with kids. And that, in my opinion, this would be a really great way to utilize mentors. It's good for them to establish rapport and do fun things, but the mentors, if they could really plug in to help a kid get to work maybe once or twice a week, that would be great. The case plan task must develop activities to develop relationships, coping skills, and emotional well-being. Again, I think working is a great way to develop skills, coping skills. You have to work with people in your professional life, and that's just the beginning for them. And also help them have a sense of pride. When you get a paycheck, a kid's going to feel proud of him or herself. So I think that our statutory scheme supports that, and we should be pushing for that. And here's our Social Security income, the different types that are available to kids in care. So SSI, if the child, him or herself, has a qualifying disability, and they may get the SSI benefit. Those SSI benefits, our little funnel pictograph here, it all gets funneled into the master trust. Social Security benefits for adults who became disabled as a child, and if they had that qualifying disability before the age of 22, and the parent is retired or deceased, and they collect Social Security, that young adult may receive a monthly benefit. That type of benefit is not limited for the type of benefit for the master trust. So some types of funding are limited and have to be drawn down. The master trust is not limited for that middle benefit. And just as a plug for our ongoing trainings, Robin.Rosenberg is going to be doing a full-fledged training on master trust. So I'm going to kind of fly by the master trust slides, and I won't spend a whole lot of time on there. I do have some resources, and we also have the upcoming training on master trust, which is a whole training unto itself. This is just really for the purpose of saying these are types of funding that are available to children, and where do they go when they come in? Do they go to the kids themselves? No, they don't. They get funneled into the master trust. And then the last one we have is Social Security disability benefits based upon the parent's death, disability, or retirement. Again, that type of benefit is not limited within the master trust. So if a kid had a parent who died and they're getting that derivative benefit, that benefit is based upon what the child, the amount, what the child may be eligible for is going to be based upon what the parent's work history was and what they paid in. And that ends at age 18, or if the kid is going to school full time as a high school student, it can be continued until the age of 19. And here's more about the master trust. I'm going to go through kind of quickly because we have a whole booklet on master trust. We have a whole booklet on money, and we have an upcoming training. But just the takeaway would be that there is a fee assessment that is monthly, that is on the master trust. So once the funds flow through into the master trust, they're drawn down based upon a fee assessment that's monthly. And there is a right to ask for that fee waiver a waiver of that fee assessment for some particular reasons. That's one of the youth rights that I outlined on the right-hand side to the bottom. They have a right to apply for the fee waiver. They don't have a right necessarily to exempt themselves absolutely, but they certainly have a right to apply for it. They should know about it. And there's a whole packet on how to do that. Reserve funds, when a child turns 18, they have a right to what is in the master trust, and they have a right to have those funds given to them. And if they have any funds from Social Security, there's the option to return those funds to Social Security. But I think it's easier if you plan ahead. That money can go directly to them rather than being sent back to Social Security and then having somebody chase it down to Social Security. So because of that, I think we should be making a plan when the youth is 17 or 17 and a half. So we know we can kind of gauge how much is going to be given to the youth. What are some ways that we could best spend that, particularly with education or maybe a car or something that the youth is going to need, so that we have a plan. We can help them plan before it gets into their hands and gets frittered away. And then there's a minimum personal allowance, the allowance of $30, which changes by the Social Security Administration, cannot be taken out of the master trust, and it can't be taken away as the personal allowance. What do the youth have a right to? They have a right to know where their money is going. So they have a right to provide input on that spending plan, particularly kids that might want to, have a direction, or they may not have a direction, and we're helping them get a direction with either education or training. The department has to prepare an accounting every 3 months, and that accounting has to be attached to the most recent JR, which is the judicial review that's filed with the court. And again, they have a right to apply for that fee waiver, and they have a right to be notified of the items purchased that are exceeding $500. So for example, if they get a computer to help them with maybe they want to go to online school, that should show up on their accounting, and they have a right to be notified in writing of those purchases. And here are some monies that do get to go to the youth in their direct pocket. So there's an allowance that comes out every single month. If you're not aware, that allowance is available only for kids that are in out-of-home care. They don't get it if they're with a relative. That would be up to the relative to give them. And that allowance can't be held as a punishment. So if the kid doesn't do his or her homework, it can't be leveraged for good behavior or bad behavior. It's an amount of money that is discretionary for the youth to be able to spend, so they have some autonomy. It's not a lot of money. So when as a parent myself, is oftentimes chore money is leveraged as a punishment or a reward. In this case, it cannot be, but let's not get to it because it's only $10 to $20 a month. That amount is set by the CBC, so it varies from county to county, CBC to CBC. But once it's set, it's set. And the youth, this is, I think, an important one for the teenagers. The youth don't have to buy necessities with that allowance. So they don't have to buy shampoo and conditioner and soap and deodorant and those types of things. They don't have to purchase school supplies, clothing, or other necessities out of that allowance. That should be coming out of the board rate, and the allowance amount is simply for them to have some pocket change. And with inflation, $10 to $20 a month is breaking down to what, like $5 a week, maybe. So we're talking about not much more than chewing gum or maybe one Starbucks a week. And they don't have to earn this allowance. There's nothing that says that the caregiver can't give them chores and can't give them additional allowance for chores, but this is not that type of allowance. This is not the typical parent discretionary allowance that if you have kids at home and you say, you know, you have to take out the trash every day, or you have to, you know, take the dog for a walk. Those are not those types of chores. This allowance can't be tied to chores. It comes to the child regardless. And here's our additional resources that I promised you guys. There's a master trust and fee assessment. It provides more information about that, and there's links in there for you to read about, so that if you have a kid in care who wants to apply for that fee waiver, they can do so. And the topics are indexed in this money booklet, so that one is really kid-centric. So if you have a young person that you want to pass that along to, it's a great resource. And that can be found, it's hyperlinked in here, but it also can be found on our website, which I've included in most of the slides. And then we have our normalcy statutes. This is for so that kids that are in foster care can have a right to participate in normal childhood activities. I have lived experience as a foster parent, and when I was doing it years ago, it was difficult to have any babysitters for kids that weren't fingerprinted, that weren't in the system already, like other foster parents, to provide even just you know, a night out with your spouse. So these normalcy statutes were put into place so that kids could, so that caregivers and foster parents can have normalcy, that the things that you would normally have going on in families, field trips, time with relatives, those types of things, that age appropriate activities for kids, that can go on without having to come into the dependency court and get a court order each and every time. So here's our statutory authority and framework. We are going on the reasonable and prudent parent standard. So what would a reasonable and prudent parent allow their child to participate in? And again, what are we talking about? We're talking about participation in normal childhood activities. And then there's our Florida Administrative Code that follows the statutes that further breaks it down. We also have what is covered under normalcy. So here's our audience participation. And I put some what ifs in here. If Jose wants to participate in football and his foster mom has a permission slip that says that the participation in the activity is inherently dangerous, and now she's afraid to let the foster child participate in that, can she sign the form and allow him to participate in something that is considered to be inherently dangerous? And so if you want to put in your answer in the chat, the answer is, even though you might have a liability waiving portion on a permission slip, yes, a kid can participate in sports. And that was one of the things that if you were a foster parent taking care of a foster kid and you saw a permission slip like that, you might get afraid and you might not allow a kid to participate. This is what the normalcy statutes were put in place to do. So we have another fact scenario here. Karina's grandmother just died. She's in foster care and she wants to get a tattoo of her grandmother's initials. Can the foster parent give her permission to get a tattoo? So kids under 18 are going to require a parental figure to sign who thinks that we can allow a foster kid to get grandma's initials. We have, I'm monitoring the chat. A lot of people are saying no, and I agree. That's a permanent alteration or alteration rather of a child's body, and we're not going to allow a foster parent to give permission for that. And then Hannah wants to go on a cruise for her senior trip. Her class has done fundraisers and the trip is covered, and her foster parent signed for her to go. You can drop your answer in the chat. This one is kind of one of those law school fact patterns that some of us had, and I know not everybody that is on the session is a attorney necessarily. These sessions were meant for everybody, but it really it depends answer, right? Because where's the cruise going to? If the cruise is going out of the country, is it a day cruise? Is it just going in the Bay Area, day trip and coming back? Or is it going out of the country? Certainly, if it's more than just a day trip, then yes, we're going to have permission from the parents, because it's going to it would require out of the country travel. And so, yes. However, if it's just going out to sea and coming right back, I think definitely the foster parents could sign a permission slip for that. And then Franco wants to join ROTC. He will receive weapons training, and can he participate? And I put that on there because you have kind of two competing things, right? We have ROTC, which is sort of a normal school participation activity. But then we also have the weapons training, and some people have really strong feelings about weapons and kids being exposed to weapons. So I think on that one, if we can get parents to weigh in on that, I think that's the best course of action. And if we don't, if parents are not available, then I think that would be something that a foster parent or a relative caregiver, I think that is something that they could give permission for. A lot of these, when it comes into how it plays out in real life, are the answer of it depends. Some of them are hard and fast yeses, some are absolute no's, and then we have our gray areas in between. And so I put a little bit of everything in those fact patterns. And then we also have what we know is considered normal. So we have our extracurriculars, sports, youth group activities, service organizations, outings with peers, driver education, vacations with family, field trips, and summer camps. So those are the yeses. We should put a little green check mark on all of those. So on my football scenario, yes. Service organizations, I would argue that ROTC fits within that, so I would give that a yes. Outings with peers and vacation with family. If our cruise would have been, instead of a cruise, if it was a beach vacation instead of out of the country, then that would be a definite yes. It's just when we have those, maybe outliers that we have to maybe think to ourselves, should we get parental permission or court permission? These are some bullet points where parental authority remains even after disposition. So until the parent's rights are terminated, so during the pendency of the case, a parent retains some rights to make decisions and not the caregivers. So the parent's rights are subject to the court's authority because the court has jurisdiction. The judge gets to make the ultimate determination if there's any arguments. And we have our gray area over here on, it's not clear to the extent of the parental authority on all issues, but they do have to give permission for psychotropic meds and educational placement. So, we have some ranges, some yeses, some no's, and some in-betweens. If in doubt, take it to court. And then, of course, as Jory mentioned at the beginning, some of our youth tell us, I didn't know I could get a driver's license. I didn't know I could drive. And this has been in play for quite some time now, the Keys to Independence program. And the intent is we want kids to be able to do normal things. And so this is under the Normalcy umbrella. And what are some of the normal things? We want them to be able to drive and go to work, drive to go to school, see friends, participate in extracurriculars. It does give them funding for driver education, licensing costs, and car insurance. And hopefully that will lead to them getting a job so that they can purchase their own vehicle, because unfortunately we don't have deep enough pockets to provide kids in care cars. Were it so, we would be hearing all kinds of celebratory comments from kids. Unfortunately, it does not cover cars, but it does get them behind the wheel and at least licensed with car insurance. So it is definitely a benefit to our young people. We also have our sibling youth rights, the right to connect, siblings and family. Robin and myself, we did a sibling training. I want to say it was in last year. So if you're interested, this is an excerpt. We don't have the time to do it in its entirety, but there is a sibling only training that you can tune into if you're interested. So this is the rights of kids to connect to siblings and family. We have the goals in Chapter 39 when it comes to siblings are to keep the siblings together whenever is possible. Whenever possible doesn't mean always, always, always. But when we do not have them together in placement, we want them to have frequent visitation and communication when they are apart. And we want to keep them connected. So the purpose, the sibling connection, it was added to the definition section of our Chapter 39. We want to make every possible effort for kids in care that if there's a sibling group, that they stay in the same home. And if they, in the event of a permanent placement, to place them in the same adoptive home. And if they are separated, we want to keep them in contact with each other. So sometimes we have kids who maybe have needs that exceed that of the siblings and they can't be kept together. But if there's other reasons they can't be kept together, then we want to make sure that they at least stay in contact, visiting or talking frequently on the phone. We have our 394805 goals that we started with. And the legislature has recognized that that it's important for kids to be placed in a home with not more than one other child unless they're part of a sibling group, that they should enjoy visitation with their siblings at least once a week with their sibling unless the court orders otherwise. Again, you know, we are, I'm in a very large county. Does every single one of my kids get to see their siblings in person every single week? No, a good portion of them do. Sometimes if they're scattered out of county, they can see each other in person maybe once a month, but can have unlimited contact to video chat. Or to play video games together on those video game connectives, gaming consoles and the like. So we can be creative. The visits don't necessarily always have to be in person. We would like them to be in person, but they can be substituted in just to make sure we keep that sibling connection. And our sibling definition is here. So we have a child who shares a birth parent or a legal parent. So that means half siblings, that means all derivations of siblings. And subsection B says a child who has lived together in a family with one or more other children whom he or she identifies as siblings. So that's more of our fictive kin. That means not necessarily strictly related, but that they identify as their sibling. The number of siblings that a child has can only increase. So if we have a set of siblings or one or more siblings, and they have had their parental rights terminated as to that child, it doesn't sever the sibling relationship, and it doesn't, and if they are adopted into a new family, it doesn't dissolve that sibling relationship. So I think that's important to recognize, because not every child has the same permanency goal. Sometimes we have younger siblings and older siblings with an age gap, and maybe the older one would be better off if their case went permanent guardianship and they could get extended foster care benefits or something of the like. And maybe the decision for the youngers is to put them in an adoptive scenario. It does not, the permanency posture does not dissolve their sibling relationship. They have a right to be placed together whenever possible. At shelter, DCF should be making reasonable efforts to keep the kids together. The preference is for a foster home instead of a group home, and in fact, is relative instead of a foster home. DCF must recommend frequent visitation unless it's harmful. And what would that look like if one kid is beating up another kid, maybe? And other ongoing interactions. And we have to report to the court about ongoing placement efforts. So if the kids are separated, it's not a crock pot situation. We don't fix it and forget it and leave them separated. We think about it all throughout the case. Family finding, I put a bold subtitle in here: relationship building, even if it's not a placement option. We should be not just looking for placement options. Let's not get tunnel vision and only think about placements. Let's think about building relationships, because when these kids go home, that can be the family that is surrounding them can help support reunification. Or if they cannot go home, it's going to be the relatives and the relationship building that happens in this child's life that helps them in the future. Somebody they can lean on, somebody they can ask for a ride to a job interview, or those types of things. A good part of the calls we get from Florida Children's First is from youth who are in crisis, that who have aged out and are homeless, or their placement disrupted as soon as they didn't get the board rate anymore. And so we want to build as many relationships as we can for kids. So we don't want to just stop short of placement. We want to look at family finding. Family finding program must use diligent efforts. So it actually says it in the statute that family finding efforts must go beyond basic search tools. So we're talking about more than your basic Google search. We've got to really be looking for family. And searching for and locating adult relatives and fictive kin, and identifying and building positive connections between the child and the child's relatives and fictive kin, so that we can support the engagement of those relatives and family, so that they can kind of come together. We want those people in the child's life. We want them to be participating in staffings. We want them to be mentoring those kids. We want to maintain all of those family connections when possible. And we want to keep siblings together when it's in their best interest and when possible. Again, back to our MDT staffings. If you can't tell, I'm a big fan of MDT staffings. There's a lot of work that gets done. It's a more relaxed environment. Court happens rapidly. We can take a little bit more time in our staffings. The scope of work includes placement decisions. So I think it's really great to have all the team players that are involved with the child at the table. And when we're assessing placement, we need to be looking at the willingness and of the caregivers to support those family and sibling visits. We don't want to place a child with a set of caregivers that wants to cut off all communication and cut off all ties to the bio family as soon as the case is over. That's not good for kids. And so here are some of our statutes. 4024 subsection 3A. We need to have reasonable efforts going on to place siblings together when they enter. And when reasonable efforts again to place children who enter care with siblings who are in care. So that's the scenario where we have a whole group of siblings coming in together. And before we move them from a placement, the MDT team must consider all the best interest factors. And DCF and the court are not required to move children to develop a relationship between siblings. So that's the case of a child born into care. We have a sibling group in care, and a new baby is born. We're not required to move a child that's been in a placement to reunify with a newborn baby. We do want to place siblings together whenever possible, but we don't want to be moving kids at the expense of building a relationship with a brand new newborn. The MDT is convened whenever we have to consider a placement that's going to impact the sibling relationship, and we want to look at it from the perspective of each child. So we don't look at it from like a blob of siblings perspective. We look at it from each child's perspective because like when we looked at one of our first slides, the child's age, the child's preference, the child's maturity, their cognitive ability, all of those things come into play, and they're not the same for each child in the sibling group. If a caregiver is willing to accept this sibling group and the MDT staffing recommendation says it's suitable for each child, then they must be placed together. If they can't be placed together, then there must be contact and visitation. And here is some other framework that we need to be looking at in the context of placement of siblings. Regular contact with siblings is critical to maintaining those attachments. It's the longest relationship that we have in our lives. The caregivers have to respect those ties and assist with visits and communications. The DCF and CBC should be providing support to address those caregiver concerns if there are any. And we want to prioritize family placements and hopefully place kids if they're not together. We want to put them in a geographical proximity so that we can promote contact. And let's be creative with our contact. I have a kid now who their sibling visitations occur a lot of the times at his football games, so sister can watch him play football. But it doesn't have to be the same exact thing every single month. It can, or week, can be different joint experiences. Respite care can be a form of sibling visitation. And I think this one's an important one to talk about. If a kid is misbehaving and they're not doing their homework or they're not following the house rules, we're not going to be using communication with siblings or family as a source of punishment or reward. It's neutral. You have a right, kids have a right to have contact with their family, with their siblings, with their parents. And it's not conditioned on whether they're following the house rules or not. They have a right to communicate with their siblings that are not in care. So when we have that sibling age gap and one of them ages out, they have to be allowed to communicate with their siblings who emancipate or reunify if the sibling and the parent consent. So that's a big if, right? So if we have a kid who is going to emancipate and age out, or if we do have a kid that's going home and maybe for whatever reason some of the younger siblings are not, then let's address that and get the parental consent while things are humming along and everybody is in good collaboration before things break apart. Children in care have the right to have the court consider the appropriateness of communication with anybody who leave care for any reason. So we don't have to, it can be their former step parent. It can be, a cousin's cousin. It can be anybody. And we want to listen to what our kids are telling us and who's important to their life, and try and get those contacts before they leave care. The court has to consider the recommendations of DCF, CBC, and the other information before making its decision. And siblings in care have a right to seek continued communication with those who leave by adoption, by the consent of the adoptive parent, or by court order. Agreements for continued communication between adoptive and children and relatives. That is one that happens, unfortunately, frequently, where the continued communication between siblings is not addressed in written fashion in the adoptive plan. And then, maybe the adoptive parents of one sibling cut off communication to the other sibling. We want to make sure that, to the extent possible, we put that in the adoptive court order, so that the kids don't lose contact if the adults in their lives decide that they don't want to do visitation anymore. The right to know the location and contact of the sibling. Kids get separated sometimes in foster care, and they do have a right to know the location and contact information of their brothers and sisters. If DCF or the CBC doesn't know, then they have to make reasonable efforts to get the info. We can't just shrug our shoulders and say, geez, I don't know where your sibling is. We should be talking to the other kids and caregivers in those kids' cases to find out where they are and how we can be effective in getting those kids together. Limits on contacts and visitation can only be limited if the court finds that it's contrary to the safety or well-being of the child. That doesn't happen at the caregiver level, folks. That doesn't happen at the staffing level. The court has to make that finding. And the court must order the CBC to provide services. If we can, like say in my other example where one kid is beating up on another, maybe we put in some protective measures, and we go about sibling visits in a more structured way, or maybe we get sibling therapy going. But let's try and not limit sibling contact as our first option. And then relatives, so we're kind of shifting focus beyond just siblings and into relatives. So the definitions are here. They're broad, right? We're including grandparents, great-grandparents, siblings, and and family is a broad definition as well. And then we have even a broader definition for fictive kin, which means that it's not really a relative, but it's somebody that the child has an emotional attachment to, a significant relationship, and maybe they considered somebody in their life important that was an auntie and is no longer a relative. And so we've added in a fictive kin definition so that we're looking at it again from the child's perspective. And here is our statute for visitation with parents and relatives. Maternal or paternal grandparents as well as step grandparent is entitled to reasonable visitation. In family law, we don't have grandparents' rights, but in dependency, we do. So when I talk to grandparents out in the community, most grandparents know or have been told grandparents don't have rights in the state of Florida. That is true in family law, but they do have rights to visit their children, grandchildren rather, in dependency. And a child should have regular visitation with their parents at least once a month unless the court orders otherwise. That's during the pendency of their case. If it's post-TPR, there is a statute for post-TPR connections and ongoing communications, but that has to go through the court. And then we have our independent living and permanency goals to include kin-like connections with supportive adults. And I put this in here again because if a kid is not going to, if they're going to go the independent living route and they're not going to be adopted, we really need to make sure we establish those family connections and supportive adults, because when the lights go out on the case, and the child ages out, they need to have that support. And that support, more often than not, comes from family or family-like connections. Visitation with parents and relatives, under the statute 396221, our guardianship orders. Take a look at your guardianship orders. Those are a lot of the time boilerplate. Everybody is kind of high-fiving and in a more relaxed state when a case is finally to closure. And if a kid is going to go permanent guardianship, the guardianship orders, they must address the frequency and nature of visitation with the child's parents, the child's grandparents, and the child's siblings. And when you're thinking about, when you're, oftentimes these orders are drafted by CLS attorneys, and again, kind of in a routine rote manner. Let's take a closer look. So the next time you have a guardianship order that comes across your email for you to review, think about the enforceability when you're drafting. Is the visitation provision specific enough? Does it say, according to the statute, it says the frequency and nature of the visitation. So if that visitation is not happening, is it specific enough in the order to be enforced? So that's my practice tip to myself as well as to everyone else on the session here. Visitation with parents and relatives. If the case is going to go adoption, the legislative intent is that when the siblings are separated, despite diligent efforts to keep them together, what is that post-adoption communication or contact among the siblings going to look like? And it may be ordered by the court if it's found to be in the best interest of the children. So this is one of the areas that it's a checkpoint for us to be thinking about. What is that post-sibling visitation going to look like? That post-visitation communication or post-adoption communication, what is that going to look like? And a child has the right to have the court consider it. Is it always going to be ordered? Maybe not, but again, from a child-centric perspective, a child has a right to raise it with the court, and a child has a right to be heard, and for the court to consider the factors, which would be, whether it should be in person or whether it should be written. Is it going to be telephone calls? If the siblings are geographically separated, maybe cost is prohibitive to do in person all the time, but encourage the adoptive parents and those that are caring for the other siblings to really make a concerted effort to keep those sibling contacts in place. And that's it for the slides. I know I have not been monitoring the chat as much as maybe Robin or Jorge have been, so I'll turn it over back over to Robin at this point.
Thank you so much, Christine. You jammed a lot of information in. You came in under time. I did try to answer all the questions in the chat. Jorge said he will be able to include a transcript of the chat for those of you that have asked for it. In that, you will also see my email address. Some of you had some particular questions, want to do some follow-up on sibling visit issues, and we are happy to talk with you all about everything that's pending. I think all the questions in the chat were answered. Christine, you're getting pats on the back from folks, but we will hang on here and just see if there are any more questions that come in the next few minutes. But really appreciate, Christine, all your work and covering so much material at one time. Jory, did you have any final message you wanted to make?
Thank you so much for coming.
Yeah, we really appreciate everybody. And we look forward to seeing you next month when we talk about hidden foster care. So have a great day, everybody.
I did drop, to finalize it, I did drop a materials link. I will be including the copy of the slides as well. Robin was like a hawk answering all these questions in the chat, so I did what I could to try to compile a document that will be in the materials. For whatever reason, anybody sees a question that was missed, feel free to email me, and I'll get that question back to our speakers to see if we can make sure that to have them all answered. Feel free to start emailing me for those certificates of attendance. I'll let those pile up a little bit so I can handle all those at the same time. So I dropped the CLE code in the chat. It will all go out via email. So thank you again for all of our amazing speakers. I did want to do a quick plug for the public interest law section because Robin happens to be the chair of the Children's Rights Work Group, and I think we may have Janine here, who's the chair of the public interest law section. So if you're an attorney or you're a law student, you should definitely take a look at PILS at the website if you're already a member and you're interested in this type of area of law. Make sure to look at the work group because it's an amazing work group. I think it's probably the most active work group that our section has, and they always do amazing work. So thank you everybody for joining us. Let me make sure we don't have any other questions in the Q&A. I see a question about how do I get credit for the course. I'm going to send you a CLE code that if you need to submit credits for the Florida bar, you can use that code. But if you need a certificate of attendance, email me and I will create one for you hopefully by the end of the day. So I think that's pretty much it. We're at time. So thank you all again. Christine, amazing presentation. Thank you, Robin and Jory, for joining us. I'm going to drop my email in the chat. And here, if you miss it, don't worry, you're going to get an email with all this information. So no worries. I'm going to try to drop it here before we wrap up because I know it's sometimes hard to copy an email from the chat. And there you go. Hopefully I don't have any typos. All right.
Everybody.
Thanks, everybody.
Thank you, everybody.
Bye-bye.
Bye-bye.